This conference will now be recorded.
Hello, everyone, and welcome to the webinar for applying apportionment law to the conclusive presumption of Labor Code section 4662A. My name is Lauren Zalona, and I'm a partner at RTGR Law. RTGR Law provides legal services for employers, insurance companies, and public entity agencies all throughout California. We have offices all over the state. We represent in workers' compensation cases, disability and employment law issues, and subrogation and liability law, just to name a few. Today, we're going to go through some interesting case law that's come down regarding apportionment and the conclusive presumptions of Labor Code section 4662. If you would like a copy of this presentation, please feel free to reach out to me personally at laurenz@rtgrlaw.com or your nearest RTGR Law office. Each of these emails are connected to the most senior attorney in that specific location. For example, I'm in San Jose, so if you were to email sj@rtgrlaw.com, the email would come to me and I can answer any of your questions, provide you a PDF of the PowerPoint or whatever else you need. We'll have this slide at the end as well. So as you go through the presentation, you start to have some questions, you can get that email at the end as well. So just before we begin, again, we have a disclaimer that this information is provided for educational purposes and should not be construed as legal advice on the subject matter. But if you do have a question or you need legal advice on a specific case or whatnot, please feel free to reach out to any one of the emails listed on the prior page that we'll go through again at the end. Or you can email me, Lauren, Z as in zebra, @rtgrlaw.com. So this is our agenda for today. The first section is going to be just apportionment in general. I know everybody watching this webinar probably has heard the word apportionment before, and specifically we'll dive into Labor Code section 4662, the conclusive presumptions. Then we'll get into the cases that have recently come down that have caused quite a stir in this area. We have the Clockner case, which was first in time, and then a few months later, the FREYR case. And then we'll discuss kind of where this leaves us with these two opinions and what happens when the authorities are split on a particular issue. So, as many of you may know, the employer is only liable for the percentage of permanent disability directly caused by a work injury, right? What we know as AOE, COE, arising out of and in the course of employment. Apportionment is one of the few legal theories that defense attorneys hold the burden to prove. So this is other than affirmative legal defenses. So examples of some of the affirmative legal defenses you may have heard, right, are intoxication or self-inflicted injuries, initial aggressor, or one of my favorite, skylarking, also known as horseplay, right? When we're asserting those defenses, the defense has the burden to prove, right? And then the burden shifts back to the employee. Normally in a case, right, the burden starts with the employee to prove AOE, COE, right? So apportionment is one of those legal theories that the burden starts with us. So there's a claim, a worker has established AOE, COE, and if we want to try to show that, a portion of their permanent disability is not directly caused by the work injury, we as defendants have to show that, right? We do that through medical evidence and other tools, but apportionment is one of those, special legal theories that some may forget that the defense actually holds the burden on. Now, there are multiple sections of the Labor Code that discuss apportionment, and I've kind of laid those out for you here. Labor Code section 4662 is implicitly involved because of the conclusive presumptions and now this case law, right, that we have. So it's kind of intertwined with the subsequent sections 4663 and 4664. Now 4663 basically says that physicians, they shall consider causation of permanent disability. It actually mandates, by using the word shall, that doctors in workers' compensation cases have to consider causation of permanent disability. So this is something that we always, like to remind doctors in our cover letters, or any other communications, with the doctor or depositions, that they actually must consider causation of permanent disability. It is mandated in the labor code by that language shall. Now, Labor Code Section 4664 is where we get the language that the employer is only liable for permanent disability that is a direct cause of the injury, of the permanent disability. And this is where you see apportionment to prior awards. Now, it can get a little complicated. Let's assume the prior award is post January 1st, 2013, because after SB 863, there were some changes. But if you have an injury that's, say, 2015, same body part, the person injured their knee, and later they have an injury to the same knee, a doctor actually has to address that prior permanent disability award. And we usually can do a straight deduction of permanent disability, right? So if the first award was for 15% permanent disability and the second was for 30% permanent disability, make my math easy, right? We're left with an additional 15% disability that the current employer would be liable for, right? And that's where that comes from Labor Code Section 4664. That notion that the employer is only liable for permanent disability. That is a direct cause. So let's go back to Labor Code Section 4662, the conclusive presumption, because this is what the webinar today is going to be focused on. Now, Labor Code Section 4662A provides that the following are permanent disabilities that shall be conclusively presumed to be total in character, okay? Essentially meaning there's going to be an award of permanent total disability. And that would be, as they're listed here, the loss of both eyes or sight thereof, loss of both hands or the use of thereof, an injury resulting in a practically total paralysis, and an injury in the brain, to the brain resulting in permanent mental incapacity. So the issue that came up here, right, is whether this labor code section, whether apportionment applies to these, right? And immediately after section 4662A comes our other labor code sections, 4663A, which is, as we just discussed, apportionment of permanent disability shall be based on causation. And also 4664A, which says that the employer is only liable for the percentage of permanent disability directly caused by the injury arising out of and occurring in the course of employment. So the issue becomes, for the courts faced with an injury under 4662A, is to what extent does the Labor Code mandate that apportionment is applied to Labor Code Section 4662A? So there's two cases that address this question. As I noted, the first in time was Clockner USA Holdings versus the WCAB. And the second, only months later, is a March 2020 decision by the WCAB called FREYR v. California Department of Corrections and Rehabilitation. And it's actually so new that we don't have the citation just yet. I do have a copy of the case if anybody is curious of the actual decision. And it was basically an opinion and decision on reconsideration. It was never appealed to the Court of Appeals. Maybe the case settled or something. But if somebody would like a copy of that decision, I can email it to you. Just email me at laurenz@rtgrlaw.com. So let's go over Clockner v. WCAB. Now, this is a writ denied case, essentially meaning that the the workers' compensation judge made a decision. It was appealed to the Workers' Compensation Appeals Board on reconsideration, and whoever lost, in this case the defendant, basically then appealed to the California Court of Appeals. The Court of Appeals denied the petition for writ. Now, that doesn't necessarily mean that it makes it any more binding of the law. It just means that the Court of Appeals did not feel it was ripe for adjudication at the Court of Appeal at that time. But it is a writ denied case. Now, in Clockner, the WCAB, which is the recon unit, right, affirmed the workers' compensation judge's finding the applicant suffered an industrial injury causing, among many other injuries, there were multiple parts of body, a mental incapacity as provided by Labor Code Section 4662A4, right, thereby entitling applicant to an unapportioned award of permanent total disability. Now, the QME in Clockner opined that the applicant's industrial head injury aggravated or lit up a pre-existing neurodegenerative disorder, basically resulting in cognitive dysfunction that qualified him under this presumption. Now, the WCAB concluded that there was evidence to support that the workers' compensation judge's finding of permanent total disability based on the conclusive presumption of Labor Code Section 4662A4, which, remember, was the mental incapacity, due to severe brain injury and mental incapacity, and that when an injury is conclusively presumed to have caused permanent total disability under the Labor Code, under 4662A, apportionment to non-industrial factors is not applicable to reduce the award. Okay, so this was the finding under Clockner. So the applicant was entitled to a total, an award of permanent total disability based on Labor Code Section 4662A, because according to the court in Clockner, the apportionment was not applicable to reduce the award. Now, FREYR is a split panel decision. So this came months after Clockner. This decision came out in March 2020. And a split panel decision basically means there were some judges in the reconsideration unit that decided one way. The majority of them decided one way, right? And then there were some that did not join that majority opinion. And this case actually does have a dissent. And I'll go through that in a little later. But as far as the authority goes, it's made it to the same level of appeal that the Clockner case did, that being the highest court to adjudicate the issue was the reconsideration unit. However, like I noted, Clockner was appealed to the Court of Appeals, but they declined to hear that case. Now, FREYR was not, that I can tell, ever appealed to the Court of Appeals. The case could have settled, or maybe the parties decided not to do an appeal. So it doesn't necessarily make either case more binding than the other, maybe more persuasive, right, depending on which side you're coming from. One is a writ denied, but the other one is more recent in time, right? So this is where we kind of get a rub, because now we have these two cases that are conflicting. So let's talk about FREYR and why it's conflicting. So in FREYR, the applicant suffered multiple injuries to different parts of the body, and there were three different dates of injuries. So we have a specific injury on May 23rd, 2005, a September 11th, 2006, and a June 28th, 2012 injury. Now, I kind of have to condense the facts here for you because, they're detailed, but what really mattered here, though, was that the workers' compensation judge awarded two separate permanent total disability awards in the specific injuries of September 11th, 2006 and June 28th, 2011. So essentially, the judge was saying these two dates of injury alone each caused permanent total disability, which has some issues in itself. But in any case, all three of those claims had multiple parts of body that were pled, and many of them overlapped, right? So we also now have these facts about apportionment in general, and a case called Benson, you may have heard, which is apportionment among dates of injury, right? So we have a lot of issues kind of coming up from this FREYR case, from these facts. So according to the medical legal examiner, the September 11th, 2006 injury and the June 28, 2012 injury involved cardiomyopathy that was related entirely to pre-existing diabetes, but the diabetes mellitus was significantly aggravated and accelerated by applicants' inability to exercise and the psychological aftermath of the two aforementioned dates of injury. So in addition, we had an AME, who's an ophthalmologist, who opined that applicants suffered legal blindness in both eyes due to the September 11, 2006 injury and the June 28, 2012 injuries, and a string of medical events that superseded those dates. So there was apportionment provided in this case, like I talked about how, right, we have multiple dates of injury. So the doctors were faced with the challenge of having to divide the permanent disability among these multiple dates of injury. Now it came out 60% of applicants' permanent disability to industrial causes, split 30% to the September 11, 2006 date of injury and 30% to the June 28, 2012 injury, and then 40% of the disability to pre-existing causes. Now, the workers' compensation judge ultimately awarded the applicant permanent total disability given the legal blindness diagnosis and Labor Code Section 4662A. And in making the finding, the judge noted that although medical evidence established that only half of the applicant's permanent total disability was caused by her June 28, 2012 injury, the conclusive presumption of Section 4662A(1) precludes apportionment of applicant's permanent total disability. Now, this case was appealed to the reconsideration unit, and they accepted to review the case. And in a split panel decision, they were faced with the task of determining, right, whether this apportionment applies and whether the apportionment and the conclusive presumptions can coexist. And ultimately, they decided that apportionment should apply. And they really stayed true to what we call statutory interpretation, where they realized there was no answer in Labor Code Section 4662. And so they looked at the Labor Code sections surrounding it, right? Labor Code Section 4663 and 4664, which are essentially, as the legislature's writing these sections, the idea is if they wanted something to exist, right? If they wanted there to be some kind of anti-attribution clause to prevent apportionment in Labor Code Section 4662, they probably would have written it into the Labor Code section, right? But instead, they went into Section 4663 and 4664 and wrote the language of those, and in those prescribed that permanent disability shall, remember that language, shall be based on causation, and that the employer shall, right, that's mandated language, only be liable for the percentage directly caused by the injury. They didn't say that permanent disability may be based on causation or the employer may be liable, right? They used the language shall. And the court took that as if they wanted there to be some apportionment or, anti-attribution clause or some inability to apportion, they would have included it. But look, here, the subsequent sections give us this mandated language to provide apportionment. The majority opinion basically stated that the plain language does not exempt permanent disability that is conclusively presumed to be total pursuant to Labor Code Section 4662A. So again, like I said, they didn't include language in 4663 or 4664 that said this does not apply to Labor Code Section 4662, right? So they also alluded to the need for apportionment under Benson. Okay, I noted that case earlier. The apportionment to separate dates of injury that must be considered, right? When we have multiple dates of injury, overlapping body parts, you have to consider each injury to each body part and the dates of injury, right? Because again, we have that causation of injury, right? If it's caused by a different date of injury, the doctors shall provide that apportionment. So the majority remanded the case back down to the trial court level, right? And to basically redecide permanent disability and apportionment in the applicant's 3 cases in light of the correct legal principles that permanent disabilities are conclusively presumed to be total under section 4662A and are subject to apportionment to causation under 4663 and 4664. Now, there was a dissenting opinion, as I noted, which cited Clockner. The dissenting opinion essentially hinged their written opinion on public policy, right? That there are certain public policies that are made by the legislature to provide certain benefits, and that Labor Code section 4662A is one of those public policy sections that, if somebody suffers disability from any of those listed injuries, they should be presumed to be total. And then the dissent cited Clockner as an on-point case. So even within the reconsideration unit, we have a split in authority, right? But the majority opinion did conclude that apportionment applies, and therefore that is the precedent we use going forward. But of course, we still have the Clockner case. So where does this leave us when we have 2 very different opinions on a similar issue? Well, one of the, an answer can arguably be found in the footnote of the FREYR decision. And I always love when, courts put these gems of like a decision in a footnote, right? Because, you find them in the footnotes and they actually had the biggest impact, right? So in this case, footnote 5 of the decision, they explicitly stated that they're aware that the dissent cites to the appeals board panel decision and writ denied case that concluded completely opposite, right? That the injured employee's permanent disability under 4662(1) apportionment cannot be applied. But then they go on to say explicitly that it's well established that neither panel decisions nor writ denied cases are binding precedent on the WCJs of subsequent appeals board panels, and that they do not have any stare decisis effect, meaning we are not bound to follow them as, say, we would be a California Supreme Court decision, right? So they're basically saying, yeah, they had a different conclusion, but you know what? We're on an equal footing when it comes to who has binding precedent, and we're deciding this other way. So, it's rare that we see courts flat out just say, nope, the other court got it wrong. This is what we're deciding, but they did that here. The FREYR majority concluded that the panel decision and writ denied case in Clockner, upon which the dissent relies, was erroneously decided. So they just came out and said it, right? So now what happens when there are split in authorities? Like I said, both are technically good persuasive authority. Neither of them is completely binding. So another case could come up and we have both of these decisions, and just like the footnote 5 said, right, the decisions of the WCAB are not binding on other workers' compensation judges necessarily. They are persuasive, but they're not binding. And so this is where the Court of Appeals really needs to make the decision, right? These are issues that are ripe for adjudication at the California Court of Appeals. And so when a case does come up with these issues, and one side is citing Clockner and one side is citing FREYR, there's going to be a judge that will make a decision. That decision will probably get appealed to the recon unit. The recon unit probably will take it and make a decision, and then it will be carried on into the Court of Appeal. If the losing attorney on the recon level decides to take it to the Court of Appeal. And it is extremely ripe to do so because we have a complete opposite, opposite conclusions on the exact same issue. Like I said, or like I say here, right? They're eliciting the same application of law, yet the ends are in stark contrast, right? This is where the Court of Appeal would be ripe to come in. So we'll see what happens. I'm keeping my eye on this, and it's an interesting split in authority on a very interesting issue, not only because apportionment is always ever evolving, but also because apportionment is one of those legal theories that the defense does have the burden. So I'm extremely interested in how this will play out, because it also has effects on not only other sections of the Labor Code section 4662, but also just in the use of apportionment in general, right, and permanent total disability cases. So we'll see what happens. Thank you for joining me for this webinar. I hope it was helpful. If you have any questions, again, please feel free to email me at laurenz@rtgrlaw.com. I can also send a PDF copy of this PowerPoint. You can also email any of the California local offices. All of our offices are listed here. We handle cases at boards all over California. So if you have, especially if you have a case that would elicit the facts brought up in this presentation, please feel free to reach out. I'm watching this very, very closely. We also can offer continuing education credit. You can go ahead and send me an email with the subject line being CE credit, and I'll email you a certificate of attendance and with documentation of your participation. You can also find out more about RTGR Law on our website, but also we have a blog that we are constantly updating with changes in the law, especially now given everything with COVID-19. We have webinars on that and the recent bills that went into effect that were signed by the governor. So please do check out our website, check out the blog. You can connect with us on LinkedIn and follow us on Twitter. A little more information on our firm here. As I noted, we do workers' compensation, civil subrogation, and employment law. I look forward to hopefully being able to help you soon on some of your cases. If you would like to reach out, again, laurenz@rtgrlaw.com. And thank you very much for attending this webinar, and have a great rest of your day.